Good evening to one and all present here. This is Ruksha Ahmed, Executive Member at Legal Vidya, and I welcome you all to the second day of our workshop on cyber law and cyber crimes. The recording of today's session will be shared shortly with all registered participants. We look forward to your active participation in this session. Now, without further ado, I would like to invite Govind sir to kindly take over the session and guide us through today's topic.
Hi everyone, I hope I am audible now. So basically what we're going to talk about today is that how are these virtual uh, investigations taking place? How do these investigations take place which become the very part of the digital investigation at last? Now, what we need to talk about is that what are these investigations? How do they come into the very structure? And what is the procedure of these investigations? Now, basically, what we need to understand is that now that we know what the crimes are, we know what the crimes and the criminal system, how does it work? What we need to understand is that how the investigation works, okay? This session is not going to be very long because investigation procedures are not very long as such. So, under section 66, the investigation authorities are basically decided. Sorry, under Section 78 of the IT Act, only a police officer not below the rank of an investigate inspector can investigate the IT offense. Practically, cyber offenses are handled by the State Police Cyber Cell, CBI Cyber Cell, and in case involving national security, the National Investigation Agency, that is the NIA. The Computer Emergency Response Team under the Ministry of Electronics acts as a national watchdog and coordinating with the ISPs, that is the internet service providers and data centers during the attacks. Yesterday we talked about attacks, right? So how many of you have ever received some document or some message stating that this is particularly a issue going on and your KYC will be expiring in the morning?
Yes, sir, I have received it in a SMS, sir.
Yeah. So when such SMSs come, this is the time when you have already been cyber attacked. Basically, what happens during such things is that people start to come to conclusion that the whole issue of the system is gone. Basically, they think that somebody has actually decided to understand that they have been hacked, and then we try to click on those links. When we click on those links, it becomes a cyber attack. Now, basically, there are five steps to procedure of investigation. The step one is that FIR registration under section 154 of the CRPC or through the new uh, criminal laws under the new sections or through online portal that is cybercrime.gov.in, you register an FIR. The second step is that there is seizure of digital evidence. Officers make a minor mirror image of the hard disk and maintain a chain of custody. Basically, what do you mean by a mirror image is that the same device and the same data is created into another storage device, that is a hard disk, to show that how the data fiduciaries are working. After this, in the step three, a forensic analysis takes place. Yesterday, we were talking about the hash verifications, the IP tracing, and the metadata recovery. So basically, step three is that forensic analysis takes place. In this forensic analysis, the hash value is taken out, the IP tracking is done, and the metadata is recovered. Now, step four is interrogation and filing of charge sheet under the. Now, step four is basically interrogation and filing of charge sheet under section 173 of the CRPC. And step 5 is presentation of electronic evidence before the court with a valid Section 65B certificate as required by the Evidence Act. Now, what we need to understand is that procedure of investigation is not just on paper. When we talk about procedure of investigation, this investigation is altogether being done to find out the actual culprits in a matter. So these culprits cannot be found out just by the very procedure that, okay, fine, we found someone. We need to go down to the very core as to who all are involved in this particular case. So in this, the police, what does they do is they get into the layers of offenders. There are multiple layer of offenders in cybercrime. There is not only one offender in a cybercrime, there are multiple cyber offenders. When I say there are multiple cyber offenders, it basically means is that there are multiple people who are involved in a cyber crime. It is not just, for example, I am the one who's doing the crime. There would be 5 or 7 layers down who would be doing the same chain, who will be part of the same chain of transaction. Now, basically, adjudication under the IT Act. What does adjudication mean? Section 46 creates adjudicating officers, usually IT secretary, that is information technology secretaries, who decide civil contraventions like data theft or negligence under Section 43A. They can award compensation up to 5 crore rupees. For higher amounts, the jurisdiction shifts to civil courts or high courts. Now, basically, what we need to understand is there is something known as adjudicating officers and usually known as the IT secretaries. Now, the power which has been given to them for awarding compensation is very high. They can award compensation amounting up to 5 crore rupees. Now, when we say 5 crore rupees, that is too high. Generally, no statute gives you the power to award something with before going to the court to the level of 5 crore rupees. Now, basically, the second question is why are such high awards available? The answer is very simple to that because the data that is being stolen is not very small in nature. There are a lot of principally involved natures to it which cause the whole system to corrupt. It can destroy the whole life of an individual when we talk about data structures. Now, after this appeals from these two people, after the civil court and after the IT secretary, the appeal goes to the second person who's called as the Cyber Appellant Tribunal. Now, this is basically Cyber Appellant Tribunal is basically a specific tribunal which is meant for cyber attacks and cyber cases. Now, basically, it has been merged with the TSAT by the notification in 2017. Now, this notification basically states that the Cyber Appellant Tribunal would be merging down with TSAT. Now, I would give you an example. So, if your client's company server is hacked, so if your client's company server is hacked and there is a loss of 2 crores in contracts, you don't file an FIR first, you move an adjudication complaint before the designate officer under Section 46. What would happen? In this particular case, it will become a complaints case under the Cyber Appellant Tribunal. Basically, when it becomes a complaint under the Cyber Tribunal, what happens is you have to start to come into the very contention and uh, using the investigation as part of the complaints case. It becomes a complaints case. Like under CRPC, something becomes a complaints case when you directly go and file a complaint, right? So here, if you go directly and file a complaint under Section 46, it becomes a complaints case. Now the next part, sorry, I am not very well today because of fever and uh, sore throat, so I might get confused in between. Now, another part three is basically what we're going to talk about is what is digital evidence and its admissibility. So, basically, digital evidence talks about a lot of things. When we talk about digital evidence talks about things like transparent uh, glass, okay? Now, when we talk about digital evidence is basically talking about it is something like glass. When I say it is something like glass, it loses its authenticity if something which is to be done is not done properly. Now, what happens is that what is digital evidence? Can anybody tell me from out you all what is a digital evidence? Anybody?
Any electronic evidence, sir? Any like in WhatsApp or something like that, emails and all.
That is correct, ma'am. So basically, when we talk about electronic evidence or digital evidence, it is basically like glass, transparent but fragile. Because if you do not get the hash value, that whole evidence goes for a 6. One wrong touch and you lose it all. And the whole authenticity goes for a 6. When I talk about the authenticity part of it, what happens is that the whole evidence is based on something, but the originality, that is why we say a mirror image of the original device is to be maintained. When we say mirror image, basically it means that the actual mirror like image of an individual, the device mirror image has to be created. There should be no changes. Now, in Anwar PV versus PV Bashir, yes, Utsavi, it has been defined in section 65B. Now, in Anwar PV versus PK Bashir, 2014, the Supreme Court held that unless a 65B certificate accompanies the record, the evidence is inadmissible, no matter how genuine it looks. What we need to understand in practicality is whenever you are submitting a pen drive, or you are even submitting for that matter a record of WhatsApp chats or anything that is digital in nature, you have to have the Section 65B certificate accompanied by it. Because without that, that particular document or that digital artifact will not become an evidence. That means basically a WhatsApp chat, a CCTV clip, or even for that matter, an email, all needs certification from the person who's in control of the device. Now, when we say who's in control of the device, what we mean to say here is very simple. In control of the device means the actual owner of the device, not anybody who can just be having some access on the device. So basically, what we need to remember is, and which is what is the key takeaway here, is that always remember that in cyber trials, authenticity overweighs volume. A single verified log beats 100 screenshots. So, what I mean to say here is that, for example, there are 1,000 screenshots in a case, okay? And out of those 1,000 screenshots, you do not have the logs. Logs means the digital artifacts for all of them. But there is one small document or one small artifact which is basically linking the whole case to the digital artifact that you're about to use. That particular thing would be more important than any other basic documents that are available with us. Now, basically, what we need to understand is about the Budapest Convention. Anybody who can tell me what is the Budapest Convention on Cyber Crimes 2001? Even wild guesses will work.
Sir, it is the first international convention for addressing cyber crimes that gives us provisions about the investigation techniques, then what are the cyber crimes and how it should be protected, especially when there are cross-border data transactions, sir, data transfers.
That is so
And
true.
to add, yes, sir.
Shivani, I'm so happy that you're well read and you
Thank you,
prepared
sir.
in advance. So basically, what we're going to talk about in the last part of our today's session is international cooperations in cyber crime control. Basically, the theme of this part is going to be because internet has got no borders, but justice still does have borders, right? How do we come up with conclusions that what is going to happen where, who's going to be staying where, how are things going to happen, and who's going to decide what? So now let's just address the most complex challenge in cyber laws, that is the international cooperation. The internet has no boundaries, but the law still does. A hacker sitting in St. Petersburg can breach into a bank in Mumbai, and the server may be in Singapore. That data stored in California, and the data stored in California, and the victim sitting right here in front of me in Delhi. So when the crime crosses borders, whose police acts, whose laws apply, which court has the jurisdiction? This is where the world needed a global treaty, and that is when the Budapest Convention on Cyber Crimes 2001 was born. As Shivani correctly said, that it is one of the first international treaties on cyber crimes, and it is one of the first steps in the world of cyber crime. It was the first international treaty to harmonize cybercrime laws and procedures across the nations. There are about three basic goals. I want you to write this down because if you are writing some exam on cyber laws in coming days, you would need this. Basically, first is to standardize offenses. The Budapest Convention 2001 came into existence because there were three broad goals. The first goal was to standardize offenses so that hacking, data theft, child pornography are recognized crimes across jurisdictions. Does anybody know that child pornography is not a crime in some of the countries? Can anybody name a country where child pornography is not a crime even today? Anybody? Okay. Tomorrow, give me an answer to this. Now, second is to establish uniform procedures for investigation and evidence collection, especially electronic evidence. And the third one was to enable international cooperation through fast track extraditions, mutual legal assistance, and data sharing. Now, basically, under this convention, signatory nations are required to criminalize core cyber offenses like illegal access, illegal interception, data interference, system interference, and misuse of devices. It also lays down the standards for procedural powers, such as preservation of data, search and seizure of stored information, cross-border access to stored traffic data. Basically, what happens here is that if somebody has got illegal access to data, this particular convention, that is the Budapest Convention of 2001 on cyber laws, criminalizes it. If there is illegal interception of data, it criminalizes that also. If there is data interference without the permission of the sole owner of that data, that is also criminalized. System interference, that is also criminalized. And misuse of devices also criminalized under the Budapest Convention. Now comes the $1 million question. Is India a signatory to the Budapest Convention? Can anybody of you answer? Are we a signatory? Nazia has given the
No,
correct
sir.
answer. The answer is no. India has so far refused to sign the basic Budapest Convention. Why? Because we have got strong reservations on data sovereignty and jurisdictional control. Signing the convention in the current form would allow foreign agencies to directly seek access to data stored on Indian servers through foreign courts, often bypassing our domestic procedures under the Criminal Procedure Code and under the Mutual Legal Assistance Treaty framework. In simple words, India says we are not against cooperation, but we will not compromise control over our citizens' data. So, India has instead chosen the route of bilateral and multilateral agreements, entering into multiple multilegal assistance treaties with other nations to exchange evidences and coordinate investigation. As of today, India has signed MLTAs with countries like United States, United Kingdoms, Canada, France, Singapore, and Australia, among others. Mutual legal treaties, what are they? Can anybody tell me what are mutual legal treaties? Why are you all so silent today? What are mutual legal treaties? Anybody?
Sir, it is similar to bilateral or plurilateral agreements wherein the countries enter into any terms regarding any legal procedures, investigation, asylum, and such things, sir.
Okay. So basically, a MLAT, that is Mutual Legal Assistance Treaties, is like a formal handshake between two governments. One promises to help the other in gathering evidence, tracing suspects, and freezing assets in cybercrime cases. But here the problem is MLT requests are painfully slow. It works like the Indian judiciary, okay? Wherein Tariq pe Tariq goes on happening, and we as lawyers also take a lot of dates because we need to have a lot of fees coming in. So basically, because of that, the MLATs are also working very slow. But here the problem is that MLT requests are painfully slow. One. Second is they move through diplomatic uh, channels, sometimes sometimes taking months, and by then the IP address is long gone. Basically, here what happens is somebody who wants to do a cyber crime will not do it easily, right? He's gonna basically do all his due diligence before getting into something. Now, that is why the world is now moving towards a faster model, direct cooperation between computer emergency response teams or CRETs. Do we have a computer emergency response team in India? The answer is yes. Now, basically, what is the role of CRET in India? Now, CRET-10 was established under Section 70B of the IT Act 2000. It acts as a national nodal agency for response, cybersecurity coordination, and liaison with foreign computer emergency response teams. Whenever there is a cross-border cyber attack, say ransomware originating from Europe or DDoS attack on an in financial institute, the CRET in contacts the counterparts like US CRET, Japan's CRET, or CRET Australia to trace, mitigate, and coordinate real-time response. The CRETIN has also signed memorandum of understanding with countries such as Japan, Singapore, Korea, and Finland for rapid data exchange and technical collaboration. Now, how many of you know there's something known as Interpol? So, when we talk about Interpol and basically the global law enforcement networks are also helping in curbing cyber crimes. Now, beyond the treaties, there's also the Interpol Cyber Fusion Center, a joint task force operating out of Singapore, connecting cyber law enforcement from over 100 nations, not from one, but from 100 nations. Through Interpol, Indian investigators can issue notice for locating a cyber offender abroad, obtaining technical intelligence or tracing stolen cryptocurrencies also. Though cryptocurrencies legal status is not very clear right now in India, though we have been hearing for a very long time that the digital rupee is going to come into India. For example, in 2021, basically the uh, Interpol basically works as a neutral international platform because cybercrimes, unlike traditional crimes, leave footprints across multiple jurisdictions. For example, in 2011, 21 ransomware case targeting Indian hospitals, Interpol helped coordinate between Delhi Police Cyber Cell, Europol, and FBI Cyber Division to trace servers operating out of Romania and Nigeria. That's how fast and borderless cooperation now needs to be in the cyber world. Now, what is basically the future of global cyber cooperation? All of you here, some of you are, must be much elder to me in profession, some of you are much younger to me. I would take the liberty to call you all my friends. The future lies in multilateral digital diplomacies. India is pushing for a United Nations Crime Convention, a new treaty that reflects that the concerns of developing countries, respects national sovereignties, and still ensures effective cross-border corporations. This will likely supersede or complement the Budapest model in coming years because cybercrime is not just another server anymore. It is about the sovereignty of a nation. The next decade will see countries forming cyber command centers, joint forensic labs, and even real time intelligence grids that share data across jurisdictions within hours, not months. It takes months right now to actually come to some data to come in. Now, next is so remember this, the fight against cybercrime cannot be won in isolation. It requires lawyers, technology people, requires technologists, diplomats working together across borders. We can have the best national laws, that is section 66, section 66C, section 66F, and 67. But if the criminal is sitting in another country, those laws mean little without cooperation. Law without reach is like justice without teeth. That is why international cooperation is a luxury. It is a necessity, and India's challenge is to strike that delicate balance between security and sovereignty. The law must protect not only our networks but also our nationhood. And, ladies and gentlemen, in this global world, the global face of cyber law, we need to be safe and we need to be in a world which is safer for all of us. I'm open for questions now. Are there any questions?
Sir, first of all, thank you for giving us insights about the aspects explained, sir. Can you tell us what are the lacunas that you found in Budapest Convention? Uh,
See, basically, Budapest Convention gives any country immediately every right to ask data from me. Now, for example, if some crime has happened in one country and that has affected my national security, Budapest Convention basically gives them the right to ask for that data which has basically affected my national security and sovereignty also, which becomes a big issue. For a country like India, our national security is very important. Now, for example, we are a signatory and Pakistan is also a signatory. A Pakistani individual has done something on the Indian defense systems. And Pakistan says now under the Budapest Convention, you are a party to Budapest Convention. Now give us all the data so that we can actually realize what has happened. Now, while giving that data, our national security goes for a six. Because all of a sudden, we are in a standstill wherein we have to give our national security data to a enemy nation. Though Pakistan is not an enemy nation officially as of now, but still it is a hostile nation. So that is one of the biggest drawbacks of the Budapest Convention.
Yes, sir. Thank you, sir.
Anybody else? Any other questions? Meera, do you have any questions? It seems to be a very silent class. Was I too boring today? You can tell me if I was boring today. It's okay.
No, sir. Maybe because it's the weekend, people are not interactive.
Okay. Now that there are no questions, I would like to end the call. And I hope you had a good session. Now, when we talk about the next day, that is tomorrow, we would be dealing with the last and the concluding session of our whole thing. Now, uh, day three, basically, we're talking about privacy and future of cyber law. Now, how many of you will be there tomorrow? Because it's a Sunday. I do not know if all of you would be there, but I hope to see some of you there. Basically, we're going to talk about what is the future of uh, cyber laws. What is going to be the. Sajesh, you have a question?
No, not a question. I just wanted to say I will be attending.
Okay, okay. Thank you. Thank you. So we will be talking about what is going to be the future, what are the fundamental rights under the uh, Legal Legitimacy and Proportionality Act, and how is the Digital Personal Protection Act going to help us shape the future of India. So that's about it, and thank you for attending. Good evening, everyone. Bye bye.
Thank you, sir. We'll attend tomorrow.
Thank you.
Thank you, sir.
Thank you.
Thank you, sir.